Body. So giving MonaMedia a second to ready themselves to begin. Perfect. Good morning to you all, particularly the students in the MonaLaw Constitutional Law class and other MonaLaw students who are present this morning. Some may be joining us online, and I want to offer a special word of welcome to students from the Caveville campus who are joining us live on YouTube. And my expectation is that my colleague in CCHR at Caveville, Mr. Rico Yearwood, is probably online with us today. Special welcome to our very distinguished guests. It's my pleasure to welcome everyone on behalf of the Faculty of Law to a conversation about Caribbean constitutional law with the eminent, His Honor, Mr. Justice Adrian Saunders, President of the CCJ, and the Honorable Dr. Lloyd Barnett. And by the way, it is L-L-O-Y-D and not L-O-R-D. Dr. Barnett, repeatedly in examinations, I hear about Lord Barnett. Such is their sense of you. Little do they know about you and your feelings about lordships and monarchical structures. Both are sizable experts in this area, and they have delivered as a lawyer and a judge some of the weightiest decisions in Caribbean constitutional law. And I just mentioned some of those we know well. Hines and the Queen, which I think is responsible for me getting past the pass mark in constitutional law 30 years ago. Independent Jamaica Council for Human Rights, and Marshall Barnett, which is the first case constitutional law students often read. The Queen and Hughes, in the case of the Honorable President, this is one of the very few decisions, well, maybe it's King and Hughes, sorry, that the appeal was won at the Court of Appeal. One of the few death penalty cases. Often the appellant is the person on death row. The decision of the President, while acting as a justice of the Court of Appeal, is legendary and played a significant role in the decisions of the Privy Council in both that case and the case decided on the same day, which is raised, the Belizean case. Zuniga, the Joseph case, a joint decision with the then President de la Bastide, the McEwen case. Constitutional law, as you know, is our fundamental law. It addresses our conception of the good life and justice, as Professor McIntosh put it. It's aspirational. It's also pragmatic. It's designed to elaborate the structure of government and to keep our government in check. It's the law we meet every day of our lives. And as Dr. Barnett reminds us, it's not just a text. It comprises statutes, especially, for example, for those of us who are in an electoral cycle. Now all of those laws are constitutional law, constitutional conventions, unwritten principles, and judicial precedents. There is no final exposition of all of these forms of constitutional law in the Caribbean than Dr. Barnett's 1976 book. And I maintain, as its 50th anniversary approaches, that it is the best law book ever written in the English-speaking Caribbean. And that comes from somebody who is part of the profession whose job it is to produce textbooks. Constitutional law, as you know, is taught at Mona by Jeffrey Foreman on the podium, at the platform rather, Assistant Attorney General Dion Jackson Miller, who needs no introduction, Catherine Williams, who unfortunately had to be in court, a partner at Livingston, Alexander and Levy, Marcus Goff, lecturer here at MonaLaw, Stephen Harvey, an associate at Livingston, Alexander and Levy. And our philosophy is that students must quickly develop 3 skills in constitutional law. You may call them phonetically the 3 R's. They must be able to read law, to reason law, and to write in legal terms. We think first-year students do so through their command, as you often hear, of the 4 C's, Caribbean constitutions, the cases that interpret them, commentaries in respect of constitutional law from the experts, and core constitutional law concepts. We also think that as teachers, it's important to learn by seeing constitutional law in action, including having a relationship with the makers, if I can put it that way, those who have indelibly shaped constitutional law through their advocacy, through their interpretation, and their attention to constitutional reform. Today is an unparalleled opportunity to do so with the president of the CCJ and the Caribbean's constitutional law giant in Dr. Barnett. To that end, I'll quickly hand over to Year 1 student, Ashanti Ford, to introduce the president, and then to Year 3 student, Joel Taylor, who will introduce Dr. Barnett. Ashanti?
So good morning, everyone. As most of you already know, my name is Ashanti Ford, and I am from St. Vincent and the Grenadines. It is a pleasure and privilege to introduce one of the region's most esteemed justices and president of the Caribbean Court of Justice, also a native of St. Vincent and the Grenadines, the Honorable Mr. Justice Adrian D. Saunders. Justice Saunders has carved out a remarkable legal career spanning 4 decades, marked by dedication to justice, judicial reform, and education. He began his professional journey as a barrister and solicitor in 1975, and shortly after built his law firm of Saunders and Huggins. In 1996, Justice Saunders was appointed to the Eastern Caribbean Supreme Court as Chief Magistrate, and in 2003, he became a High Court judge. He ascended to the ECSC's Court of Appeal in 2003 and assumed the role of Acting Chief Justice from 2004 to 2005. Justice Saunders has led a diverse and impactful life, blending a notable legal career with significant contributions to Vincentian society. His early engagement in politics as a leader of the United People's Movement, his sports achievements as a national table tennis player, cricket wicketkeeper, and leadership role in youth development underscores his multi-faced talents and commitment to public service. His judicial work, particularly in constitutional law, has profoundly influenced societal norms and individual rights in the Caribbean, as seen in landmark cases such as Hughes and Spence and McEwen. In 2015, Justice Saunders was appointed to the eminent position of President of the Caribbean Court of Justice, the final court of appeal for several CARICOM countries, and which we hope will be for the remaining members. Recognized for his advocacy of judicial integrity, Mr. Saunders was appointed to the advisory board for the Global Judicial Integrity Network by the United Nations Office on Drugs and Crime. President Saunders is a prolific legal scholar and educator. He has authored numerous legal articles and co-authored the seminal work, Fundamentals of Caribbean Constitutional Law. He actively promotes gender sensitivity in the judiciary, collaborating with UN Women and gender-sensitive protocols for the judicial office in the Caribbean. Justice Saunders exemplifies a lifelong commitment to the advancement of law, justice, and judicial education in the Caribbean and beyond. His leadership and contributions have left an indelible mark on the region's legal landscape, shaping the future of the judiciary and fostering greater integrity and inclusivity within the legal profession. Over the course of his career, Justice Saunders has built a reputation as a fair, thoughtful, and principled jurist. We are truly grateful that he has taken the time to be with us today and share his insights into constitutional law. Ladies and gentlemen, please join me in welcoming the Honorable Mr. Justice Adrian D. Saunders.
Good morning, everyone. My name is Joel Taylor, General Secretary. And to a great extent, the legal landscape in Jamaica. His legal career began as an administrative officer in the government of Jamaica for 5 years, subsequently assuming the role of Crown Counsel in the Attorney General's chambers and the Office of the Director of Public Prosecution. Thereafter, he entered private practice, the fruits of which are how we now know him quite well as a constitutional law expert. To many legal scholars and constitutional law students, his involvement in cases challenging the imposition of the death penalty, such as the Crown and Lambert Watson, R and Pratt and Morgan, and other human rights cases such as DPP and Kurt Mollison, Independent Jamaica Council for Human Rights, and Syringa Marshall Barnett et al., and famous among all your groups, Hines and the Attorney General, has proven valuable to students' understanding of the Jamaican Constitution and the importance of advocacy for human rights in Jamaica. This is so considering the sound arguments he presents in these matters. For those not so inclined to the field of law, his various publications on human rights, such as The Constitutional Law of Jamaica and The Jamaican Constitution, Basic Facts and Questions, of which the second edition is to be launched on March 7, 2024 at 6 p.m. at the St. Luke's Church Hall, are some of the informative and revelatory materials he has contributed to the area of constitutional law for the civic education of the average Jamaican. Furthermore, in this context of constitutional reform in Jamaica, his membership and contribution to the Constitutional Reform Committee will give guidance as Jamaica seeks to transition to a republic. His leadership and involvement in various organizations, such as former senator in the Jamaican Parliament in the 1980s, former chairman of the Independent Jamaica Council for Human Rights, past president of the Jamaica Bar Association, former chairman of the General Legal Council of Jamaica, member of the Caribbean Council for Legal Education, and former chairman of the Advisory Council on National Security, and all these demonstrates his yeoman service to the legal profession, development of constitutional law in the Caribbean and to Jamaica. It ignites a passion in all of us to live a life of service, uprightness, decency, honesty, and impeccable integrity, as he lives and epitomizes. As a result, in 1999, he was awarded the Order of Jamaica for his outstanding contribution to jurisprudence and legal education in the Caribbean. This morning, we esteem him greater than all his qualifications combined, and believe me, they are many. However, his invaluable contribution to the area of constitutional law is a gift that keeps on giving. I cherish him this morning because as a true Calabar man, he continues to demonstrate what it means to attain the utmost for the highest. Ladies and gentlemen, please welcome Dr. Lloyd Barnett.
thank you very much to our first and third year students. You can tell the pride which comes from coming from the same country, having gone to the same school. And it's equally a source of pride for us to have this chance. I'm quite listening in my seat, but brimming with excitement. I know my fellow teachers, John Jacksonville and Jeffrey Foreman, knew how important it is. I think particularly Dr. Barnett, that next year will be 50 years since the Hines decision. The following year, 50 years since you published your groundbreaking PhD work. It is an extraordinary privilege to have the opportunity to sit with you and with President Saunders. Both of you have spent significant time together in different spaces, including the Regional Judicial and Legal Services Commission. I wanted to start, President Saunders, with a question to you, which is, you came, unlike many judges, to the judiciary from the private bar. I'm assuming based on the kind of firm you probably had, you did a fair amount of commercial and corporate work as a lawyer, but nevertheless you have developed a relationship with public law and constitutional law and a strong expertise in the area. And I just wanted to ask, how did constitutional law become an important area of work for you as a judge?
Yeah, thank you very much. I call you Tracy, Professor Ross, Tracy. And I really appreciate this opportunity to have a discussion with the students, particularly with Dr. Barnett, like I said, who I have looked up to for and continue to for such a very long time as a great authority in constitutional law. When I was your age, when I was a student at Cape, one of the courses that I did was called Citizen and the State, and it was taught by Telford Georges. Professor Georges is still regarded as one of the best jurists that the region has ever produced. There were only 6 of us who signed up for that course. It was an elective. And his style of lecturing was not really to lecture, but to have something like this, a conversation. So it was an enormous privilege for me to be one of 6 persons to sit with this great man for 2 hours a week. And in those days, we didn't have the semester system. So we had it for the whole year. And that kindled my very deep interest and liking for public law, constitutional law. As you mentioned, when I was at the bar, there was not a lot of opportunities to engage in that kind of work because it simply didn't come through the door. In those days, not very many people filed constitutional actions. But as soon as I went on the bench, one of the very first cases that I did was Benjamin, which was a freedom of expression case. And I really relished that. And after that, a lot of constitutional matters seem to have come my way, which I dealt with. But it is the area of law that I like most. It is probably the area of law in which I'm most proficient. And, it is an area of law which I think places a judge in perhaps the most pivotal position a role of a judge can have, because you have to decide people's rights, you have to determine where the balance lies between the public interest and the private rights that people should have. And so I really regard it as a very, very important area of law.
Thank you so much, President. I wanted to ask you a comparable question, Dr. Barnett, because you, in the mid-1960s, chose to do a PhD in constitutional law. And I wondered what brought you there. At just a few years after independence, I'm not sure, I don't remember which year you started, but it certainly felt like a groundbreaking field for a Jamaican student in London, supervised by the extraordinary Professor Stanley Smith. But what took you to want to do doctoral work in constitutional law?
First of all, I should say thanks for the kind introduction. I'm sorry. Thanks for the very kind introduction. One of the first rules of legal practice is that you should listen carefully to the key points. And in that introduction, you would notice that the key points was past and forward. And that was repeated several times. The interest in constitutional law probably arose from a history, an interest in history, because I did constitutional history as one of my special subjects. I did history at Calabar, and I did constitutional history, and I did my first degree of Bachelor of Arts degree. And the special subject I selected was constitutional history. And I believe it is because constitutional matters go to the core of your existence. Because what you do and what you cannot do, your prospects, your social, economic circumstances are dependent on government, what government does and how it does it, the question of accountability, so that it is the area of law which touches our lives on a daily basis. And therefore, it is attractive as well as very consequential. And I think it is important for not only those who are intending to practice in that area, but all persons, all law students, all practitioners who have an interest in that subject.
Very much, Dr. B. I'm going to hand over the mic, so we're going to be a little bit tossing the mic around to Jeffrey Foreman.
Thank you. So we now want to move into some questions about the work that both of you have done in your careers. And I'd like to start with you, Dr. Barnett. The students who do constitutional law are now being introduced to the science space. They were reading it, having discussions about it in class. And one of the questions that came to me during this week was, how did this case come about? So I'm using the opportunity to direct that question to you. As someone who was involved in the litigation, I think from the outset, how did you come to the case? Did the case come to you? And perhaps you could speak generally about the nature of public law litigation and constitutional law litigation and the circumstances that sometimes give rise to these types of impactful cases.
Let me just answer with a preliminary comment. Let me answer with a preliminary comment. One of the first rules of legal practice is that you should prepare carefully. And then the second rule is present clearly. You can't prepare carefully unless you know what you're doing. I wasn't told what I was going to be asked, but whatever you do. So you forgive me. But the Hines case arose out of one of the first phases of violent criminal activity in Jamaica. And the government responded to the wave of crime by passing two important statutes which challenged the constitutional system. One was the Gun Court Act and one was the Suppression of Crimes Act. And in the case of the Gun Court Act, it sought to expedite the legal processes by giving certain functions to magistrates, which including trying persons for the serious offenses of illegal possession, which became even more serious because of the indefinite detention punishment which was attached to that offense. And so that when the Gun Court and Suppression of Crimes legislation started to have an impact on the human rights of Jamaicans, it attracted the concern of the human rights practitioners. And remarkably, the first Gun Court case was a case involving a young man by the name of Mackenzie, whose father was very popular in Jamaica. He had played cricket for Jamaica, as well as football. And he died suddenly, and there were 2 guns in the house where the sons lived with him. And then they prosecuted the son on the basis that he was in possession of the guns which are in the house that they lived. And so that stirred up almost an emotional response. And so we challenged the statute which had given to magistrates who were not invested with the same jurisdiction as judges of the Supreme Court, and who were not appointed, most importantly, by the same careful mechanism that judges of the Supreme Court were appointed by. And so we actually extracted from my book the approach to the application of the doctrine of separation of powers to that situation. And so we said that the government were interfering with the protection of the judiciary by vesting in magistrates who were not appointed by the Judicial Services Commission in the manner which the Constitution prescribed of powers which were suitable only to the Supreme Court for their exercise.
And sorry, if I can follow up on something you said there, the background context to what gave rise to the legislation. It occurs to me that much of certainly Jamaican constitutional history and experience has come against the background of the crime problem. The Nation case, for example, regarding attempts to shut out bail in certain contexts. And outside of the sphere of litigation, certainly the human rights community over the decades has been most vocal in matters concerning sentencing, punishments, and things of that nature. Do you have any thoughts on I guess that interplay between the state's desire to respond to what is an extremely serious problem of crime and violence in the country, and the need to strike a balance, to use President Saunders.
And Jamaica has had, and other countries, a tremendous challenge of how to deal with crime in a way which is effective but nevertheless does not destroy the fundamental principles of the Constitution and the human rights of citizens. So you have states of emergency, and the question is, how do you reconcile the extensive powers granted under states of emergency with the fundamental rights of citizens? You have extension of police powers, you have restrictions on the jurisdiction of the court to grant bail, and the clash between the anxiety to suppress crime and the principle of preserving the fundamental rights of citizens is a very critical clash, even in the most democratic countries, and will continue, I'm sure, to be a source of litigation in the courts.
Morning. I don't want President Saunders to think we don't have any questions for him. I promise we do. But I don't want to leave Hines without asking Dr. Barnett about an aspect of the ruling. Students would know that there's been a lot of discussion recently about the gun court and the fact that provisions of the Gun Court Act allow the public and the media to be shut out of court. And for full disclosure, I'm a member of the Press Association of Jamaica, which has called for the repeal of some sections of that act, specifically to let Justice Saunders know that. But I'd love your thoughts, Dr. Barnett, on the lasting impact of that aspect of the ruling, especially in the context of the open justice principle and discussions.
The Hines case was, of course, decided on the old Chapter 3 fundamental rights provisions. And I actually argued that particular point in the Privy Council. And the bloc was of the view that the Parliament had to be given the discretion to decide on whether the public should be excluded from the trials. Incidentally, he came to Jamaica a few years afterwards to deliver a lecture, and I was on the platform. I was a co-lecturer. And I told him that it was a dangerous way in which he had put it, and he said he thought he might have put it too widely. And the fact of the matter is that I do not think that approach is justified under the Charter, because you have to prove that any restriction is demonstrably justified in a free and democratic society. It's a completely different standard now. And, to just exclude the public or the press from observing a criminal trial, which is essentially a public occasion, is very difficult to justify unless you have some specific rule or some specific evidence.
Sorry, I don't think I'd said it for the students that that aspect of the ruling that point had been unsuccessful in the appeal.
So I'm going to go on here. Are you saying, Dr. Barnett, that you think that aspect of the Gun Court Act may be unconstitutional today?
The answer is yes.
Okay, I have a call to make.
To your producer?
To my president. PAJ.
You're setting up work for me.
Absolutely.
I had a question about separation of powers, but given Dr. Barnett's signal that he was not briefed on the questions, I'll hold that one for the next time we talk, Dr. Barnett, and hand back over to Dion and to Jeffrey.
If I just then, another big case that's been in the public domain has been the cartel case. And students responded on that one. And one of the questions we've heard asked is the fact that all the lawyers who appeared were British lawyers. Now, before, say one, I beg your pardon, thank you. Before I ask Dr. Barnett for his thoughts, just to say that I spoke with the Director of Public Prosecutions this morning. She gave me permission to share with you the fact that the reason neither she nor her deputy appeared or were on their feet in the matter is that she felt it would have been untidy to do so, given the fact that they were part of the case. They were in the consultation which the judge had. He called her over. Jeremy Taylor was there as well when he was canvassing opinions as to make his determination as to whether the juror should be set aside or not. She said she felt in those circumstances it would have been untidy for them to be arguing that point, and she felt more comfortable having a totally independent lawyer arguing it. She said they were there, they were, as you saw, they were assisting behind the scenes, they were meeting with Mr. Knox after the case, after the day had ended, and also that she was also prepared if the judges specifically wanted to hear from her to stand and speak. But she said that was the explanation. But I'd love your thoughts, Dr. Barnett. We heard a lot of Jamaicans saying, save for Isaac Buchanan, who is relatively junior, that they had questions when they looked at the, what should I say, the optics of the courtroom.
It seemed to me that it was a question of the judge being concerned more with the practical implications and the legal principles, because it is the normal and well-established principle in relation to jurors is that if it is tainted, you can't assess the extent that the tainting has impacted on the verdict, so that there is no real option but to terminate the trial once that is revealed. I don't agree that the prosecution, that is, when I say the prosecution, the Director of Public Prosecution should not be proactive in the matter, because the duty of the prosecution is not a duty only to the prosecution side, it's a duty to the administration of justice. And if something is going wrong, then the prosecution has a duty to intervene to prevent what might end up being a serious problem, and to say what, in the prosecution's view, is the appropriate resolution of the problem. So it seems to me that the whole thing was approached on the wrong basis.
But on the issue of the representation, was that problematic for you, Dr. Barnett? Not talking about the quality of the representation, but the fact that so many of the counsel in the matter were in fact not, as they say, of us, from us.
I don't think that's a problem. I mean, when I argued, I literally said that I was new to the matter. Yeah.
So, President Saunders, on the matter of that case, during the hearing before the Privy Council, which many students took the opportunity to watch, there were some who felt that the appellants got a better, in quotes, hearing there than they did from the appellate courts in Jamaica. And some argue that, well, the closeness of the appellate judges to the Jamaican environment and whatever ill feelings or negative views of the appellants might have clouded, prevented, not allowed the local appellate court to properly view the issues and to interrogate the various points as well as they should have. That issue of closeness has been one that arises in relation to the debate between should the countries in the Caribbean adopt the CCJ or stick to the Judicial Committee of the Privy Council. Do you have any thoughts or comments on the closeness arguments that arise in relation to the judiciary in the region?
Yeah. Okay, there are several things operating here. First of all, a second-tier appellate court, whether it is comprised of judges from this region or that region, is going to be looking at the issue with a more dispassionate approach than either the trial court or the Court of Appeal, just by the nature of the fact that it is two courts removed from the early of what went on. And secondly, it is refined legal arguments that are being made, for the most part, in the apex court. So that aspect of it does not implicate whether it's CCJ or the Supreme Court of the US or the Privy Council. But there is another aspect to that concern which I have to comment on, and that is that if it is the premise that Caribbean judges are somehow less impartial or have less integrity or less professionalism than judges of any other jurisdiction, then I reject that premise out of hand. And I think that the record will show that Caribbean judges are just as, because there's an element to that concern which it doesn't speak so much to geography, it speaks to integrity, professionalism, and impartiality. It doesn't matter, to my mind, whether you live in a small country or a large country. If you have integrity, if you are professional in your approach, and if you are impartial, those are not traits which, to my mind, are impacted by geography or by demographics. Those are traits that are impacted by the quality, the cadre, the caliber of the particular judge. And in my view, Caribbean judges are just as capable as other judges to address issues that come before them.
And you sat at the Court of Appeal level and at the final appellate level. Do you find that there's a difference in approach between the two?
Absolutely, absolutely. First of all, at the apex level, for one, there are more judges sitting. There's a big difference between one judge sitting in a case or 3 judges presiding over a case and 5 judges presiding over the same case. The greater number of judges you have, it is the greater opportunity there is for more views to be given on the subject matter and for various vantage points to be appreciated. So that is one difference. But as I said, the fact that the case has gone through a number of processes before it reaches the apex court is also another difference. A third difference is usually, not necessarily always, but often, the quality of the submissions that are made at the apex court and let's say the quality of the submissions that are made is more refined, is of a higher standard than is often made at the courts below. So all of these differences, ultimately they add up. And these are differences which would attend any final court, any apex court. They are not peculiar to the Privy Council, but they would be spread anywhere where there is a final court where you have 5, 7, 9 judges sitting.
Maybe a quick follow-up question there. Your answer, President, is fairly abstract. You know, if we think Caribbean judges have integrity and can have integrity in the same way as others, size shouldn't matter. But size does matter in the sense that you may be more likely to have worked in the same chambers as the lawyer appearing before you. You may be very good friends with counsel appearing for the other side. You may know the politician in that jurisdiction personally. Sorry? Gone to Calabar. And I think students are, one student said to me, I'm looking for you, you know, you all went to Barbados together. You know each other personally. And in fact, many of us do know each other very personally. And so I wanted, if you might just respond to that question in a way which acknowledges we all know each other, a lot of you as judges and lawyers, but nevertheless cases come to you and you decide against the Court of Appeal, or you reverse decisions of judges who you have relationships with, of lawyers who you know well. I think students concretely want to understand that you manage and you do achieve justice in your mind, notwithstanding. And I simply to say, we know in the United Kingdom, the judges, there's also considerable intimacy, certainly not unique.
But this is precisely the point, that these are not issues that are unique to the Caribbean. The judges in the United Kingdom, invariably, they may have come out of, the judges of the Judicial Committee may have come out of the same chambers as the lawyers who were practicing before them. They may have been trained at the same inn of court. So these are not, and this is why you say it's abstract, but to my mind, it's undeniable. These are issues that bear on integrity and professionalism. And when, for example, at the local levels, whether the Caribbean Court of Justice or a Court of Appeal, you have dissenting opinions. Here you have judges who live and work with each other, but they have an honest disagreement. And they publicly state that disagreement. And sometimes dissenting opinions are very sharply written. They are very robust. And so you have a demonstration of judges who are close friends, work together, who are unafraid to express their disagreement. An honest disagreement, they have a different view on a particular issue of law, and they're not afraid to express it in writing and publish it for all to see. So that I really do think that it is an irrational fear that people have when they put forward the view that, oh, we shouldn't leave the Privy Council, or that, oh, Caribbean judges are not good enough because we have small societies and because they have trained with counsel who appear before them, or the society is so small that they might know the litigants and so on. I think those are very exaggerated and irrational fears, quite frankly, because I think that the record shows that the top judges in the Caribbean would be top judges anywhere in the world. And we don't lack the professionalism and integrity and impartiality which is necessary in order to make good decisions.
Thank you very much. So I just want to recall in that 1978 visit of Lord Diplock, Dr. Barnett, where you were also on the podium, one of the first things which he said was, "This feels like a reunion." And it was the first time he was coming to Jamaica, but he recognized the lawyers who came from the same kind of legal education background that he had. And he was calling up the familiarity of being in Jamaica and nevertheless feeling as if he was with a legal family he recognized, even if he had not been familiar personally with the lawyers. And certainly, I imagine too, Dr. Barnett, you have appeared many times before the Privy Council. And by the time we get to independent Jamaica Council for Human Rights, of course, it's a different court, but they certainly recognize you. There's familiarity, even in the Privy Council jurisdiction, with the lawyers who come before it fairly often.
I have appeared with quite a number of the leading British counsel who appear in the Privy Council and in the Supreme Court. And despite the greater size of the country, my impression is that the relationship between the bar and the judges is closer than in the Caribbean. And I can tell you that in several cases I have been in, the English counsel have consulted with retired judges because they feel that that person has a sort of feel of how the persons on the bench sing. You know, so that this idea that there is a disadvantage in the Caribbean because of the size, I don't think it's right. There's probably an advantage.
If I could just add one note to that. I was not trained in England, but once when I went to the UK, someone invited me to, it was, I think it was Lincoln's Inn, to have a dinner. And the experience, it blew my mind, because having dinner together were law students, trial judges, Court of Appeal judges, and judges of the House of Lords. They all belonged to the same inn, and on this particular day, they decided to dine at their inn. And of course, they're all lawyers, so we talk law. So I could quite appreciate what Dr. Barnett says. There is a far greater closeness among them than there is, scattered as we are in various Caribbean countries, and not being able to see and dine with each other every other week, than there is in the Caribbean. So it re-emphasizes that whole fear, the premise of that concern, I think is grossly exaggerated and perhaps even totally unreal.
Yes. Could I, colleagues, maybe in the interest of time, take some questions from students? And I'm going to invite, I know that Ayana has a question for you, President. And Clavia, if I could take you first, I think you may have a question for Dr. Barnett, quite possibly. I want to take a question online. I also have Jade with a question, but let's take those questions and see what time we have after. Clavia? And to facilitate hearing My suggestion is that we may just use the podium. You can walk around the front of the room, Xavier. Come down, please. Don't worry about that. Or should we just give her a mic?
Good morning. Good morning. All right. So we're talking about the closeness of bench and bar, and I think it's somewhat related to a concern or a question or something that pops up in my head, related particularly to the doctrine of separation of powers. So in relation to separation of powers, we understand that it's a basic principle on which many Caribbean constitutions are founded. And basically, at the same time, we have the Caribbean Court of Justice that has been described as revolutionary for its view on the doctrine of legitimate expectation, where citizens can accrue rights from unincorporated treaties. So my question is, how do you respond to the criticism that legitimate expectation runs counter to the fundamental doctrine of separation of powers by ascribing lawmaking duties to the legislator to the executive?
Thank you very much. That's a very good question. First of all, let's look at legitimate expectations in the domestic setting. They arise when a citizen has a complaint about the manner in which they're treated, but they cannot find anything in the common law or in statute law that could justify the action that they wish to take. But if the court finds that, well, look, you were promised that you wouldn't be treated in this fashion, then you should be able to rely on that expectation that you had in order to get some remedy. That is what it is in the domestic setting. In an international setting, it's not very different. What we decided in the case of Boyce was that if the state, having signed an international treaty, promised you that the rights that were contained in that treaty would be adhered to by the state, even though those rights were not contained in a domestic statute, that nevertheless, by reason of the fact that they held out to you, the fact that they intended to comply with those provisions, that similarly you should not be prejudiced when they renege on their commitment to comply with the terms of the treaty. So my point is that the premise on which Boyce was decided, so far as legitimate expectation is concerned, is not essentially very different from the premise on which legitimate expectation is applied in a domestic setting. And therefore, if there is no concern about separation of powers in the domestic setting, then there should hardly be any where the promise which is made is one which derived from an international treaty that the state has signed. That's the best answer that I can give you.
It's a very interesting point. I've recently been examining it in relation to environmental rights. And it can operate at two different levels, namely the exercise of national powers whether by the executive or the legislature, in relation to matters for which the state has given a commitment in international law. And it can arise in relation to how you interpret legislation which deals with the subject matter. And there are cases in India, Australia, and elsewhere in which the impact of the commitments made by governments in international treaties have been used in relation to the issues of legitimate expectation or questions relating to statutory interpretation.
Thank you very much. Thank you very much. Thanks. So we have a couple of questions, and I want to also find some time for Cable colleagues who are online. We'd like to wrap up around 1/2 and I know we might not get to them all, but I want to acknowledge that we have a question or comment from Holly Vasquez, a Cave Hill student from Belize. We also have lecturer Rico Yearwood. There's considerable interest in the question of the test for judging limitation on rights, which follows from our earlier discussion on Hines and the point which was lost. And so there are a couple questions there. And then we have also questions from, is Carissa finished in the faculty? On the original jurisdiction, and I certainly want to take one of those. But let me first take Ayana Robinson and then Jade, and then we'll save some time for an online question.
Okay, hi, good morning everyone. My name is Ayana Robinson and I have a question for President Saunders. So towards the end of last year, probably in November or December, the Jamaica Gleaner spoke with Lord Hodge, a judge of the Judicial Committee of the Privy Council. But based off the discussion we just had, I'm wondering if you guys might know him personally after what was just said. He spoke with the Gleaner and he told them that the Judicial Committee and the Caribbean Court of Justice can exist side by side so long as Commonwealth Caribbean countries wish to retain the appellate jurisdiction of the Judicial Committee. So I was wondering, what's your hope for more countries in the Commonwealth Caribbean to accede to the appellate jurisdiction of the Caribbean Court of Justice?
Yeah, thank you, Ayana. Well, that's an issue which is purely for the determination of the government and people of the particular country. There are 12 countries that can possibly accede to the appellate jurisdiction. 5 have done so to this date. And I know there's a raging debate here in Jamaica. But it all depends on what the government, the parliament, the people of the particular country wish to do. We certainly would like them to come to the CCJ, but you know, that is simply a matter which has to be worked out at the domestic level.
Yeah, you have an ethical alternative with Trinidad, which go with criminal matters and not civil matters.
I wonder, John, if you could squeeze in a question to Dr. Barnett on constitutional reform. I feel before we get the other student, I think there's a great chance to get some feedback from Dr. Barnett on constitutional reform.
Sure, thank you so much, Tracy. One of the issues as students know why we have, as Justice Saunders referred to, the raging debate in Jamaica is the issue of how it is we're going to amend our constitutions to allow for the removal of the Privy Council and the accession of the CCJ, if indeed we do so. And it's given rise to a subsidiary discussion, I think, as to the whole issue of referendum in the Caribbean, Dr. Barnett. It used to be that we used to hang all the discussions on the West Indies referendum, which failed. But since then, we've seen referendum after referendum fail in the Caribbean on a number of different points. Do you think that it's time we look at amending the constitutions perhaps to remove the referendum requirement in some cases, or to change the levels of entrenchment of some of the provisions?
Need for referendum is really a statement that the public, the ordinary person, should have a say in the important provisions of the Constitution. So that from a democratic point of view, that is something that I wouldn't readily change. In respect of the appellate jurisdiction, it is not clear at all whether or not that requires a referendum. Before the Privy Council, there's a very strange history of this matter. Before the Privy Council, we argued that it was not correct to subject our final appellate jurisdiction to an ordinary legislative process. And that is what we won on. And then the Privy Council asked us to say whether or not it required a referendum or just a special majority of Parliament. We said immediately it required just a special majority of Parliament and not a referendum. And rather strangely, the government people said, who had been saying it should be done by ordinary legislation, now says it requires a referendum. So the Privy Council adjourned and say they won't decide immediately, so make submissions. And we held our position. They said it required a referendum, and the Privy Council said it would not make any decision on the point since it had not been considered by the Jamaican courts. So that is still very much in the air. It has not been possible for anyone, as far as I know, and the journalists can tell me if it's better, that to get from the Jamaica Labour Party government a clear statement as to what their position is on either accession to the CCJ or what is the process that they wish to be used. So that it is very much in the air.
Sorry, if I may be allowed to steal, sneak another question in. On the matter of entrenchment procedures, as the students know, in the IGCHR case, the rationale for having various levels of entrenchment was, one of the rationales was that it reflected the importance that the drafters placed on different provisions in the Constitution. And a question I've always wondered is why did the drafters of the Jamaican Constitution place so much stock in the form of a constitutional monarchy? That change requires a referendum. It wasn't. It's not required. It was not required in Barbados or Trinidad, but Jamaica has to go to that route. You're the expert.
If you want to find any logical, rational reason for it, it is purely a result of the political realities of the time, because what had happened is that the federal referendum had gone against the government. And so the government was anxious to proceed to independence as a way of showing that they were committed to Jamaica. Because part of the argument in the thing is that, we are giving away our sovereignty. And so that they were anxious to do nothing which would require a long argument with the British government. So that they anticipated that the easiest way to get our Constitution approved and the Independence Act passed is to entrench the monarchy.
Can I, so that the online audience knows that we see you, we hear you, can we take a question from the online audience on the original jurisdiction president? And the question is, and so if you see us on our phones, it's not us being impolite, but we're in conversation. So Carissa Powell, one of ours, is Carissa in final year at law school. Do you think the CCJ's exclusive original jurisdiction on referrals for interpretation and application under Article 214 of the revised Treaty of Chaguaramas is underutilized in the Caribbean? And I'm going to ask you a follow-up question, President, which is something that has been heavy in my thinking for a while. Should community law be compulsory for every student who graduates from a legal education institution that provides an LLB in the Caribbean? Both questions to you, President.
Yeah. As to the first, that's quite an understatement. It's not just underutilized, it's never been utilized. Although we've come close on a few occasions. There are a number of reasons for this. One of them is that, strangely enough, the CCJ itself allows a very generous level of access to it in the original jurisdiction, so that on one occasion, a litigant who had brought a case in Jamaica and asked the judge to do a referral, and the judge said, well, I may need to do a referral, but I don't think the time is ripe as yet, which was not an unreasonable answer, quite frankly. The litigant simply said, okay, and filed directly to the Caribbean Court of Justice, which entertained the action. The issue, you would say, well, why go to the local court if you could come straight to the CCJ? Well, the remedies that you could get, if it is in fact a domestic case, but it is and can be wrapped up in the original jurisdiction, if you went domestically to the local courts, then you may have a greater range of remedies than you might be able to get at the CCJ. So you do take the risk when you pack up and say, okay, I'm going straight to the CCJ, of limiting the scope of your remedies. So that first question is clear, that the referral jurisdiction is clearly is not being utilized. And in fact, we've gotten some money from the European Development Fund to have some educational sessions in the various states among business people, judges, and the bar to talk a little bit about that referral provision, Article 214, so that people could understand it better, with the hope that it will generate more instances of referral. As to the question as to community law, it is a fact, when the court started, some of us thought that there would be more matters filed in the original jurisdiction than there were appeals filed, because the original jurisdiction deals with freedom of movement, it deals with your ability to start a business in another CARICOM country, it deals with a variety of things that are going on as we speak, and areas where people do have problems, but not a lot of those problems are filed before the CCJ. The most famous case, the Shanique Myrie case, that was a case where a brave young lady decided to file. But for all you know, there are a lot of matters which are similar to the experience that the experiences that she had, and which, you know, people don't file. Either they are not aware of their rights, or if they discuss them with a lawyer, the lawyer is perhaps a little timid about filing in the original jurisdiction because it's all about international law, and not lawyers don't practice a lot in that area, and so some of them may be a little, you know, intimidated. But I certainly agree with you that there is a need for persons, for the general population, and in particular law students, to have a greater appreciation of the vast range of rights which are to be enjoyed under the original jurisdiction, and how they can secure those rights.
If I can add something about just a reflection on how legal systems develop. In my lifetime, at some point every year, there's normally some controversy about a Jamaican going to Trinidad or some other country and experiencing some serious problem at the borders. And this is an unscientific reflection, but I find that post my there have been less instances of that, and I'm aware that certainly within the ranks of CARICOM, that judgment has been used a lot to change procedures at the borders and things of that nature. So it's something for those who, you know, are interested in law and legal systems to reflect on the way in which precedent works to change behaviors of state actors.
That's absolutely right.
So last set of questions. You know, we had a really interesting question from Holly at Kayville around the horizontal judicial review, the horizontal application of the Bill of Rights. But again, I am guided by Dr. Barnett that we may need a little more time if we're going to answer that particular question. I also have a question, and I just wanted to ask the team whether we might be able to bring someone on Zoom. If Rico Yearwood is available, then we'll bring him on Zoom to ask his question. And in the meantime, we'll take a related question from Jane. Run up, Jane. And so, Jade, tell us who you are before you begin, and you can borrow this mic, one of them. No man, come back this way.
Good morning, everyone. My name is Jade Martin. I'm a second-year law student. So my question is directed to Dr. Barnett. Dr. Barnett, you have said that our new Chapter 3, the Charter of Fundamental Rights and Freedoms, clearly repudiates the heavy burden of proof on litigants to prove that limits on rights are not justifiable, and this is found in the case of Hines. Is the language of Section 13 enough to arrive at this conclusion, or is it assisted by the fact that Jamaica borrowed language from the Canadian Charter, where the modern burden has been long established by the Canadian courts? Thank you.
Yeah, the language is similar, and for the reason that it was adopted, and the intention was that we should reverse the old rule which made it very difficult for the ordinary citizen to prove that some government scheme or legislation was not justified. And, you know, to ask the ordinary citizen to do that was unfair because how would we assemble all the material relating to policy and sometimes technical matters which the government took into account, so that it was deliberately done in order to ensure that if you have taken away somebody's rights, you should justify why it is that you have done it.
Thank you very much. I think it's a related question. Thank you so much, Jane. We have Rico Yearwood for the last question online, and he is joining us from the Cave Hill campus. Welcome to Cave Hill. Welcome to Rico Yearwood.
Good afternoon. I don't know if you all can hear me clearly.
We can.
Yes, very good. So I extend my salutations to everyone in the physical space on behalf of the faculty and students of law at Cave Hill. I was quite intrigued by the question the student who went before me asked, because my question is quite related to that. And I'm asking on behalf of my CCHR student. So, and it follows on from what Dr. Barnett said about demonstrably justified now being the new standard for limiting rights in Jamaica's constitution. But we've seen over the years that the courts seem to be using the same tests for determining whether a limitation is reasonably required, reasonably justifiable, or demonstrably justified. Sorry. So the only thing that seems to be different, therefore, is the burden of proof. So when we look at cases like Wheel and the Attorney General of Barbados, where the court used the reasonably justifiable test to determine what is reasonably required, and the case of McEwen and the Attorney General of Guyana, where Justice Saunders himself used the demonstrably justified test to determine what is reasonably required, it seems like the essence of the test, therefore, is the same. So I just want to know what are the panelists' thoughts on that.
There has been a lot of progress in this area. It started with some African cases in which the initial very restrictive approach of the traditional formulation came to be modified. But the litigants still had the initial version in those modified versions. So that from a practical point of view, they are closer to each other now, but certainly there has been great progress. And our charter emphasized and incorporated that progress so as to make it beyond any need for argument.
Any comments on the test for justifying infringements on rights?
I have to say that the various phrases, the various phraseologies would strike a judge as being so closely related that there is not a significant amount of thought that would go into parsing the difference in language. The judge would have a sense as to whether in a free and democratic society this particular step that has been taken by the state goes beyond the pale or it does not. And little thought one does not, as I said, parse out the difference in language to that extent.
We'll wrap up here, but an interesting set of comments which are over by Chief Justice Sachs in the NITS case, in which he offers thoughts on the test in countries like Barbados, which is why Rico Yearwood's question is so helpful and interesting, because he suggests they may still be using close to the Hines test, which I would probably disagree with. But it's been a wonderful set of discussions, and I think we should honor the wonderful time which has been shared with us by both guests. And I wanted to thank certainly colleagues who are joining us online in particular, but also to give the last word on behalf of the second years, having had a first year and a final year, to Ayana Robinson to close us today. Ayana? If you hold on for 2 minutes and let us take a photograph with our guests, I would deeply appreciate it. A group photo.
Okay. Good morning, everyone. As said before, my name is Ayana Robinson, and I'm in second year. And okay, it has been a tremendous honor to be part of this most auspicious of occasions. On behalf of my colleagues here in first and second year at the Faculty of Law at the University of the West Indies, Mona, I would like to thank our highly esteemed guests, the Honorable Justice Adrian Saunders, President of the Caribbean Court of Justice, and Dr. the Honorable Lloyd Barnett, arguably one of the most eminent constitutional lawyers that the Commonwealth Caribbean has known. Thank you for taking time out of your busy schedules for this robust and wholly enjoyable discussion in which we have participated. We touched on a plethora of points, such as what sparked your initial interest in constitutional law, legislative regimes that have challenged the constitutional structure within our region, and contemporary points such as the limitations on rights amidst topical cases such as the very popular Vibes Cartel appeal. These two people who we often see in the head notes of the sometimes very long and confusing cases that we are assigned to read kept us curious and engaged today, and also showed us their distinctive humility and wit that we do not have the opportunity to see when we read these cases. I would also like to extend immense gratitude to our Professor Robinson and our public law teachers, Mr. Foreman and Dion Jackson Miller, who, as we said before, needs no introduction to us, for today showing us your enduring passion for public law and commitment to our education. And finally, I would like to express heartfelt gratitude to my fellow students who showed up here today and posed some very critical questions that made our guests think. They had to think quickly on their feet. And I think we were up there with the judges of the Privy Council who posed questions to them before. And I really appreciate you for showing up. So thank you once again to everyone, and have a very enjoyable day.
Thank you, everyone. 2 minutes for a photograph. Where we take